My humble appearance is for the first defendant. I humbly appear with my learned colleague, Elizabeth Olojede.
I am writing, please.
Sincere apologies, my lord. My name is R. Ekobedefe.
You are appearing
for the first defendant, my lord.
Yes, and appearing with you.
Elizabeth Olojede.
Any other appearances? Any other appearances?
May it please the court. My name is Mercy Ariowodion. My lord, Ariowodion is spelled as AIRIOHUODION. I appear for the third defendant.
Any appearance for the second defendant? Judgment. In reading the judgment, I shall simply read the introductory portion, and then I'll go straight to the decision portion. I hope counsel can hear me.
As the court pleases.
Judgment. The claimant filed this complaint against the defendants on May 31, 2016, together with the accompanying processes, seeking for the following reliefs. 1, a declaration that the contract of employment between the claimant and the first defendant was effectively determined by reason of a letter of restitution dated 22nd February 2012. 2, a declaration that the allegation of negligence of duty and of fraud leveled against the claimant by the first defendant is unfounded, unwarranted, wrongful, and void, and is against the spirit and intent of the letter of resignation and letter of acceptance of terms of resignation dated 22nd February 2012 and September 17, 2014, respectively. 3, a declaration that the failure of the first defendant to formally notify the Central Bank of Nigeria that the claimant has been cleared and or exonerated of all allegations arising from or in connection with the foreign exchange malpractice in the first defendant has occasioned serious damages to the claimant. 4, a declaration that the act of circulating the dismissal notice in respect of the claimant by the first defendant to the third defendant is unwarranted, wrongful, and had rendered the claimant unemployable. 5, a declaration that the termination of the claimant's employment by the second defendant based on the purported background check from the third defendant on the allegation of fraud and or negligence made by the first
I'm sorry, my
defendant.
lord, we are not able to hear, my lord. My lord, we are not able to hear the court at all. I think the network is bad.
You can't hear the court.
I don't know whether Elizabeth is able to hear for the first defendant.
Can you hear me?
I'm sorry, sir.
I can hear you, my lord.
Can you hear me now? Chief Paul, can you hear me now?
Yes, my lord.
Mercy, hear me.
Yes, my lord, I can hear you clearly, my lord.
Chief Paul, can you hear me? Well, it appears that it's only Chief Paul who can hear me. Chief Olobi, can you hear me? And the claimant hear me?
Yes, my lord, I can hear you, ma.
You can hear me?
Yes, ma.
All right. Chief Olobi, it looks as if it's your network that is having a problem. Chief Olobi, can you hear me? Can you hear me, Olobi? Another council here.
We can hear the courts, my lord.
We can hear you, my lord.
So it's only Chief Olobi that the claimant can hear me.
Yes, my lord, I can hear you, ma. Yes, ma. Yes, my lord, I can hear you, ma.
I would like to continue because the other council and the party can hear me. So the problem of the network which Olobi is using. So I would like to continue, if that is all right with everyone. If you cannot hear me at the moment in time, just let me know. I will ask the registrar that Olobi, you have his telephone number, tell him the other council can hear me. So the problem is whole network. All right. Number 4. A declaration that the act of circulating the dismissal notice in respect of the claimant as the first defendant to the third defendant is unwarranted, wrongful, and had rendered the claimant unemployable. 5. A declaration of the termination of the claimant's employment by the second defendant based on the purported background check from the third defendant on the allegation of fraud and or negligence made by the first defendant is wrongful and has occasioned a great hardship and miscarriage of justice to the claimant. 6. An order of this honorable court directing the first and second and third defendants to correct their records concerning the claimant's employment with the first defendant and clear him fully of any act of fraud, dishonesty, and or negligence. 7. Special damages against the first defendant in the sum of 220 million naira only for wrongful dismissal, termination of the claimant's employment, and for acts inimical to the claimant's source of livelihood, which damages are calculated as follows. Last annual salary from second defendant, 10,500,000 naira per annum. Number of years left to work, 21 years. Total 220 million. Or in the alternative, another directing the second defendant to confirm the employment of the claimant and accord him full rights and privileges of the manager in the second defendant's employment, and or for an order directing the first defendant to pay the claimant special damages in the sum of 875,000 naira per month from the 12th of September 2015, when the claimant's employment based on the background check the claimant at the third defendant till the date of judgment in this suit. 8. General damages against the first and second defendant jointly and severally in the sum of 25 million naira only. 9. The cost of this action in the sum of 2.5 million naira. The first defendant filed an amended statement of defense and the accompanying processes on March 22, 2022. The second defendant filed a statement of defense together with the accompanying processes on October 4, 2016. The third defendant filed a statement of defense and the accompanying processes on September 27, 2016. The claimant filed a reply to the first, second, and third defendant statements of defense on 20th May 2022, 12th June 2017, and 12th January 2017, respectively. I will now go straight to the decision portion. And if counsel cannot hear me, counsel should let me know. I hope counsel cannot hear me. Our counsel able to hear me.
Yes, my lord.
Chief Olobi, can you hear me now?
Yes, my lord. I can hear you, my lord.
All right. I go straight to the decision portion. Having finished with the introductory portion, all the other issues in the judgment. I have carefully considered the originating processes, the evidence, the submissions of counsel authorities relied on, the final address. The law is set that in the determination of employment rights, it is the employee who complains that his employment contract has been breached that has the burden to place before the court the terms and conditions of employment that provides for his rights and obligations. See the case of Abuja versus State Basin Development Authority and also Oforishe versus Nigerian Gas Company Limited. It is the law that whoever desires the court to give judgment as to any legal right and liability dependent on the existence of facts which he asserts must prove those facts exist. See section 131 and 2 of the Evidence Act. Also see the case of Calabar Cooperative Limited versus ECBO and Uwa versus Akpabio. The claimant has placed before the court his letter of appointment by the first defendant, P1, letter of promotion, P2, letter of dismissal, P10, letters of appeal, C11 to C13 and C15, first defendant's reply to appeal letter, Exhibit C14, second defendant's contract of employment, Exhibit C16, adverse CBN report, Exhibit C17, letter of resignation, C18, first defendant's reply to appeal of dismissal, C19, acceptance of terms for resignation, C20, claimant's letters to third defendant for clearance, Exhibit C21 to C24. The defendant have placed in evidence the first defendant's letter to the CBN to rescind the blacklisting, Exhibit D1. CBN circular to banks and discount houses, Exhibit D6. First defendant's return to CBN, D10. The second defendant's letter to CBN on background check. CBN letter to second defendant, D11. The third defendant's letter to the claimant, Exhibit D12. It is the law that a claim is circumscribed by the reliefs claimed, and the duty of a claimant is therefore to plead only such facts and materials as are necessary to sustain the relief and adduce evidence to prove same. See Gabriel at TVA versus Cable Metal Limited. The claims of the claimants are in the main declaratory. The burden of proof in establishing declaratory reliefs to the satisfaction of the court is heavy, in the sense that such declaratory reliefs are not granted, even on admission of the defendant, where the claimant fails to establish his entitlement to the declaration by his own evidence. The claimant has to succeed on the strength of his own case, only if the court is satisfied by evidence and not on the weakness of the defendant's case. See the case of Med versus Wankoba, International Operations Nigeria Limited versus Key Oil and Gas Services. The issues that arise for the determination in this document are as follows. 1, whether a reasonable course of action has been disclosed against the third defendant. 2, whether the second defendant wrongfully terminated the claimant's employment. 3, whether on the pleadings and evidence the claimant is entitled to the reliefs taken. A course of action has been defined as meaning a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. It is the aggregate of facts that the law will recognize as giving the claimant a substantive right to make a claim against the relief or remedy being sought. A reasonable course of action means one with some chances of success when only the allegations and evidence are considered. See the Supreme Court decision in Thomas versus Olufosoye, Yare versus National Salaries, Wages and Income Commission, Sirinko Construction Company Limited versus BP Industries Limited. All the citations in the judgment are supplied in the judgment. For a statement of claim to disclose a reasonable course of action, it must set out the legal rights of the claimant and the obligations of the defendant, the facts constituting the infraction of the claimant's legal rights, or the failure of the defendant to fulfill his obligation in such a way that if there is no proper defense, the claimant will succeed in the relief he seeks. See again, Rinko Construction Company Limited versus VP Industries Limited, Supra. A careful consideration of the statement of facts reveals that the claimant has not made any specific allegation of wrongdoing against the third defendant. The evidence at the trial revealed that there is no employment relationship between the claimant and the third defendant. To the knowledge of the claimant, the third defendant performs supervisory and regulatory functions over the first and second defendants, part of which is to prevent recycling in the banking industry of employees who have been indicted, terminated, or dismissed for acts of fraud or dishonesty. The claimant has shown that the third defendant acted in bad faith or mala fide while exercising its statutory and regulatory powers. The third defendant entered the name of the claimant in the Black Book Register and later the Miscellaneous Offences Register based on the information provided to by the first defendant. Upon the second defendant's inquiry as to the suitability of the claimant for employment and confirmation, the third defendant that his name was in the Black Book. Subsequently, when the defendant informed the third defendant, the claimant was fraud. The third defendant communicated to the second defendant and the claimant by Exhibit C25 and C29 that his name had been transferred to the Miscellaneous Offences Register, a register of offences and persons whose names are on the Miscellaneous Offence Register are not precluded from engaging in the banking industry. I find that the claimant has not disclosed a reasonable course of action against the third. The proper order circumstance one of a dismissal. See that chapter. Consequently, this against the third defendant is hereby dismissed. There is no difference between the claimant and the first, that he was an employee of the first defendant and that he was the branch manager of its Agudosi branch. There is also no between them that there was an incidence of foreign malpractice in the branch that resulted in petitions, exhibits C3 to C9, being written by the first defendant's customers. The claimant appeared before the first defendant's disciplinary committee, who recommended his dismissal as seen in the minutes of the disciplinary committee, exhibit D4. He was thereafter dismissed from the services of the first defendant on February 22, 2012. The relevant portion of the letter containing the reason for his dismissal is reproduced. Dear Victor, dismissal, malpractice on FX transactions at EcoBank, Alaba, Agutosi branch. Please recall the incident regarding your involvement in the above matter. Your actions in that respect amount to conflicts of interest. Under the bank's disciplinary code, the above is sanctionable by dismissal from the bank's employment. For this reason, you are hereby dismissed from the services of the bank from the date of this letter. The claimant appealed for a reconsideration of the decision, and the first defendant informed him in its letter dated September 12, 2012, which is exhibit C14, that, and I quote, "We are unable to accede to your request to reinstate you into the bank, as the disciplinary committee of the bank has not found any reason to alter and or amend its earlier decision concerning you," end of quote. The first defendant, by a letter dated 8 February 2013, complied with the regulatory directives of the third defendant and forwarded to its returns on its disengaged employees, exhibit D10, which included the claimant's name, wherein the first defendant requested that he be blacklisted as he was dismissed for fraud. The claimant thereafter secured employment with the second defendant and executed a contract of employment, exhibit C16, on 24th March 2014, where he agreed to the terms and conditions set out in the contract. The following terms relevant to this judgment are reproduced as follows. 3.3. This agreement is a conditional contract subject to the bank having obtained satisfactory information about you in relation to the bank's previous employment verification checks. 2, receiving any necessary regulatory approvals. 6.2, your probationary period will be 6 months, during which time the termination notice period by either party will be 1 week. 13.1, notwithstanding any other provision in this agreement, the bank is entitled to terminate your employment with immediate effect and without notice or compensation, where you have G, been disqualified or prohibited by law from holding office in the bank, any group, company, or in any other company, or been guilty of a serious breach of the rules or regulations or applicable code of practice of any relevant regulatory authority, the bank or any group company, or failed or ceased to meet the requirements of any regulatory body whose consent is required for you to undertake your duties under this agreement, or J, not satisfied the bank in respect of your pre-employment verification checks, end of quote. Now, it is common knowledge, for which this court has taken judicial notice of, that the third defendant is the regulator of banks, and by implication, the regulator of the first and second defendants. In evidence is the circular by the third defendant to all banks and discount houses on the need for its prior clearance of prospective employees of banks. The intent of the circular is to, and I quote, prevent recycling within the banking industry of erstwhile bank employees indicted, terminated, or dismissed for fraud and other acts of dishonesty. End of quote. The second defendant complied with the third defendant's statutory and regulatory directives and sought clearance from the third defendant by Exhibit G7 for verification of his suitability for employment. The third defendant replied, stating that the claimant had earlier been blacklisted for fraud and forgeries in his previous place of employment. Thus, in compliance with Section 48, subsection 4 of the Banks and Other Financial Institutions Act 2004, Ohasiri Okechukwu Victor is not suitable to be re-engaged in the banking industry. End of quote. And that's Exhibit D8. The second defendant wrote the claimant on September 12, 2014, terminating his appointment and stating the reason thus, and I quote, "We have conducted a background check on you with the Central Bank of Nigeria and have received an adverse report with regard to the circumstances of your previous employment. In view of this, we regret to inform you that we are unable to confirm your employment with our bank. We hereby notify you that effective immediately, your employment has been terminated by the bank." End of quote. It is settled law that parties are bound by the terms and conditions of the contract of service. See Sharu versus Federal Polytechnic, Kaura Namuda. Also CDA Alep, Nigeria Limited versus Oluwadari. I find that the second defendant was justified when it immediately disengaged the claimant upon receiving the adverse reports by the third defendant, who is its regulator. The claimant was also paid his full and final entitlements. I therefore hold that the second defendant properly and validly terminated the claimant's conditional employment in line with the contract of service and the regulatory directives of the third defendant. The letter written by the Central Bank to the second defendant, dated 12 August 2015, which is Exhibit D11, about 1 year after the claimant's employment was terminated by the second defendant, notifying it that the claimant's name was delisted from the Black Book and moved to the Miscellaneous Offences Register, does not invalidate the termination of the claimant's employment. I so hold. On September 17, 2014, the first defendant wrote 2 letters, Exhibits C19 and C20, to the claimant. One of the letters informs him that, and I quote, "The management is favorably disposed to your appeal and directs him to report to the Human Resources Unit with the original letter of dismissal." The second letter is reproduced as follows. "Dear Victor, acceptance of terms for resignation. We refer to your dismissal from Ecobank Nigeria Limited by the letter dated 22nd February 2012 and your subsequent appeal letter wherein you requested the bank to reconsider your dismissal. We wish to inform you that the withdrawal of the letter of dismissal will be considered only upon receipt of your confirmation to be endorsed in the space provided below that the following conditions are acceptable to you. 1, that you will not claim nor be entitled to any terminal benefits, stroke allowance, or any payment whatsoever from Ecobank in respect of your employment. 2, that the bank should withdraw your letter of dismissal and replace it with a letter of resignation. 3, that the effective date of cessation of your services with Ecobank Nigeria Limited shall be 22nd of February 2012. Upon receipt of your confirmation, Ecobank will accept your resignation accordingly from the bank. Thank you. I find that the claimant confirmed his acceptance of the terms and signed the acceptance document, Exhibit C20, on September 18, 2014. He then wrote a letter of resignation, backdated it to 22nd February 2012, which is Exhibit C18, as directed by the first defendant. The first defendant wrote to the Central Bank on December 10, 2014, Exhibit D1, informing the CBN that subsequent to the review by its appeals committee, the claimant was determined to have been negligent as a supervisor and was not directly involved in the fraud, and then requested that the CBN rescind the decision on blacklisting of the claimant. The CBN wrote the claimant on August 12, 2015, notifying him that his name was delisted from the Black Book and transferred to the Miscellaneous Offences Register, as it is confirmed that the termination of his employment was not based on fraud or any act of dishonesty, but rather on negligence of duty. The position of the law is that resignation of employment becomes effective and valid the moment it is received by the person or authority it is addressed to. This is because there is absolute power to resign and no discretion to refuse to accept the resignation of an employee. See Yesufu versus Governor of Edo State. See Waek versus Oshonibo. The first defendant, having expressly accepted the resignation of the claimant, his employment was effectively determined with effect from 22nd February 2012, and I so hold. The main declaration, Relief 1, succeeds. The first defendant was wrong in not informing the Central Bank of Nigeria that it had permitted the claimant to put in a letter of resignation on the terms agreed and had withdrawn the letter of dismissal. However, the court will not shut its eyes to all the facts leading to this dispute. Consequently, the claimant is not entitled to the declarations he is seeking in reliefs number 2, 3, 4, and 5, as they have not been proven. They are hereby refused. The ancillary order the claimant seeks in relief 6 and the award of special damages he seeks in relief 7 are both refused, having no foundation. For all the reasons given above, I hereby declare and make the following orders. 1, it is declared that the claimant's contract of employment with the first defendant was effectively determined by his letter of resignation dated 22nd February 2012. Costs in the sum of 150,000 naira each is awarded the second and the third defendants only. Judgment is entered accordingly.
My Lord, we want to thank the Lordship for the judgment just delivered. We await the certified true copy of the same for us to take the necessary steps after review. Thank you very much, my Lord.
Yes, what will happen, the file and the hard copy of the judgments will be sent to the Lagos division. But before you receive the hard copy and the file, the registrar of the court will send you a soft copy pending when you receive the hard copy. So by next week, you should receive the soft copy of the judgments.
Very, very, very grateful, Lord.
My Lord, would like to thank this honorable court for a well-considered ruling. If I may, my Lord, I am representing the second defendant. If I may humbly request that I be put on record, I had issues with the link that was sent to me.
Your name?
O.R. Ojigoro. O.R. Ojigoro is spelled O-D-J-I-G-H-O-R-O. Thank you, my Lord, and thank you once again for the judgment.
My Lord, we are very grateful for the well-considered judgments. Most grateful to the court.
My Lord, we thank the court for a well-considered judgment.
Registrar, can you call the next case? Call the next case.
Yes.
Appearances. Judgment. The claimants filed this complaint against the defendants on 17th of May 2016, together with the accompanying processes, seeking the following reliefs. 1, a declaration that the purported dismissal of the claimant hearing by the defendant, based on the report of the panel of investigation who acted on the spurious report of the police at the Panti CID, Lagos, without giving the claimant an opportunity to be heard, is unlawful, illegal, and constitutes a gross violation of the claimant. 2, a declaration that the purported dismissal of the claimant based on the report of the said panel was wrongful, inhuman, and constitutes a breach of the terms and conditions of service of the claimant with the defendant hearing. 3, a declaration that the refusal of the aforesaid panel to allow the claimant hearing confront his alleged accusers is unlawful and constitutes a breach of the claimant's rights to the inalienable rights of fair hearing. 4, an order of the Honorable Court reinstating the claimant hearing back to his duty post as a senior examination officer accounts, or alternatively, an order of the court compelling the defendant to pay all the claimant's entitlements to him forthwith. The defendant entered a conditional appearance on April 3, 2017, and filed a statement of defense together with the accompanying processes on the same date. The claimant filed a reply to the defendant's statement of defense on September 25, 2017. I will go straight to the decision portion. I have carefully considered the originating processes, the evidence, the submissions of counsel and authorities relied on in final address. The law is settled that in the determination of employment rights, it is the employee who complains that his employment contract has been breached that has the burden to place before the court the terms and conditions of his employment that provides for his rights and obligations. See Bama versus SPDC, WAEC versus Oshonibo, Okobo versus Police Council, Okomu Oil Palm versus Isere, and Idoni Boye Obe versus NNPC. The claimant has placed before the court his offer of temporary employment, Exhibit C1, Conditions of Service, Exhibit C2, Report of Investigation Panel, Exhibit C3, Letter of Dismissal, Exhibit C7. The defendant has also placed in evidence the report of the Investigation Panel, Exhibit D2, and its inter-office memorandum on the investigation of the stolen scratch cards, Exhibit D4. There is no dispute between the parties that the claimant was an employee of the defendant. The evidence before the court is that the defendant's Ikeja zonal office was burgled on 18th March 2004 and his scratch cards were stolen. The burglary and theft was reported to the Nigeria Police Force. A panel was set up by the defendant to investigate the circumstances leading to the theft of the scratch cards. Thereafter, the claimant was summarily dismissed. His letter of dismissal is reproduced as follows. Dear Mr. Oke, dismissal. The Nigeria Administrative and Finance Committee, at its 154th meeting held on 9th May 2005, considered the report of the panel, which investigated your involvement in the case of missing scratch cards at the WAEC Zonal Office, Ikeja. The committee decided that your action amounted to gross misconduct bordering on dishonesty, which contravenes Chapter 11 of the Council's Conditions of Service for National Staff, which attracts dismissal. Consequently, you are hereby dismissed from the services of the Council with immediate effect. Please hand over all Council's property in your possession, including your identity cards, to the Senior Deputy Registrar, Zonal Coordinator, Ikeja. Thank you. The issues that arise for determination are as follows. 1, whether the claimant was denied his right to fair hearing. 2, whether the defendant has established the reason it summarily dismissed the claimant. 3, whether the claimant ought to have been tried by a court before the defendant could take necessary action. The claimant asserts that he was denied his right to a fair hearing. The question is, was the claimant given the opportunity to be heard? The report of the investigation panel, Exhibit C3 and D2, and the inter-office memorandum, D4, is before the court. The evidence reveals that the claimant was queried on 25th March 2004 on the missing scratch cards, and he replied the query as seen in Exhibit D4. By his own evidence under cross-examination, he confirmed this. The report of the investigation panel reveals that the claimant appeared before the panel along with others. He was interviewed and he responded to the questions he was asked on the entire incident. It is settled law that fair hearing, ad alteram partem, is satisfied once a party has been given the opportunity to be heard in respect of any matter or cause touching on or affecting his interests. See INEC versus Musa, Ayeton versus the Nigerian Institute of Oil Palm Research. Fair hearing is simply hear the other side. How then can the claimant state that he was not given a fair hearing when he was heard in writing and also orally? The Supreme Court, in the case of Imonike versus Unity Bank PLC, has held that where an employer accuses an employee of misconduct by way of a query, and the employee answers the query before the employer takes the decision on the employee's appointment, that satisfies the requirement of fair hearing. The claimant was queried, he responded, and he appeared before the panel before he was dismissed. I find that the claimant was given a fair hearing, and I so hold. The reason given by the defendant for the claimant's dismissal in the dismissal letter is gross misconduct, bordering on dishonesty. The law imposes on the employer a duty to justify the reason given for the dismissal. See Olatunbosun versus NISA Council, also see AfriBank Nigeria PLC versus Oshisoyan. Some of the panel observations and findings on the claimant are reproduced as follows. 6. Although Mr. Oke vehemently denied any involvement in the manipulation, stroke giving out of scratch cards to anybody, and tenaciously held on to his allegations, that thieves burgled the store in the night of 18th March 2004, evidence from the computer printouts by Fleet Technologies showed that some of the missing scratch cards had been used since February 2004. That is long before the alarm of burglary. The import of the above is that the alleged burglary of 18 March 2004 is far from being real. 6. Inspection of register of sales by the panel revealed that proper books of accounts were not kept for the scratch cards by Mr. Oke. 8. The panel believed that Mr. Oke's alarm about the burglary on 19th March 2004 was born out of the common knowledge in the revenue section of a planned stock taking of the scratch cards the following Monday, knowing full well that if the stock was taken, it would be revealed that the stock of scratch cards had suffered tremendous losses, since some of them had already been used before that day, as revealed by Fleet Technologies computer printout. 9. The panel found out that none of the handing over notes of Mr. Oke to his immediate subordinate, Mrs. Fabusiwa, contained the balance of the scratch cards, whereas he always recorded the balance of receipts for her whenever he was going on leave or official tour. 10. Considering the above detailed facts, the panel believed that Mr. S.O. Oke should be held responsible for the missing scratch cards. From the evidence adduced, the claimant was in sole possession of the key to the store where the scratch cards were kept, and he was a sole administrator of the sale of scratch cards without any supervision. I find the claimant's misconduct is grave and weighty. It has eroded and undermined the confidence reposed in him by the defendant to carry out his duties. Sule versus Nigeria Cotton Board, Olatunbosun versus NISA Council. I'm satisfied that the defendant has justified the reason why it dismissed the claimant. The claimant asserts that the allegation of crime against him ought to have first been established by a court of law before the panel could act on the police report and dismiss him. The law is settled that it is not a requirement of the law that before an employer terminates the employment or summarily dismisses his employee, the employee must be tried before a court of law. Where the accusation against him is for gross misconduct, where the accusation against him is for gross misconduct bordering on criminality. C. Yusuf versus Union Bank PLC, Arinze versus Federal versus First Bank of Nigeria, Dambara versus the Attorney General of the Federation. I hold that the dismissal of the claimant is lawful. It is in accordance with the rules of natural justice and the defendant's conditions of service. Consequently, the declarations sought in reliefs 1, 2, and 3 must fail, and they are refused. The declarations having failed, the ancillary order in relief 4 also fails, having no foundation. Sinwongu versus Atuma. On the whole, the claimant has failed to prove his case. Claimant's case is hereby dismissed in its entirety. Costs awarded the defendants in the sum of 200,000 naira. Judgment is entered accordingly. Any other matter? No other matter.